What we're going to try to do today is talk about the Federal False Claims Act. Now, I'm going to give you a real good overview of what the False Claims Act is, how it works, and talk a little bit about its whistleblower provisions. Then we'll talk about the anti-kickback statute and Stark. Stark is the anti-referral legislation named after California Congressman Pete Stark, and it's primarily aimed at physicians, but we'll talk about that in a minute. Then we're going to talk about some marketing activities that can really trigger a violation of these laws. So let's get started. The Federal False Claims Act, this is a federal act, federal statute, and it prohibits, among other things, anyone from presenting a false or fraudulent claim for payment to the federal government. It also prohibits causing the use of a false record to get a claim paid by the federal government. So now in the healthcare context, this would include billing for work not performed, upcoding, billing for unnecessary services, and even billing for services that were obtained in violation of other regulations, such as the anti-kickback statute and Stark. Bottom line, False Claims Act covers fraud against the federal government. The original act was passed in 1863. It was under President Lincoln during the Civil War, and it was primarily aimed at combating fraud by war profiteers. They were delivering munitions, what were supposed to be munitions, to the battlefield, and when they opened them up, they contained nothing but sawdust. Lincoln felt something must be done, and he convinced Congress to pass the False Claims Act. Now, the act was amended in 1986 to encourage its use as a weapon against fraud. And the number of cases filed by whistleblowers since the 1986 amendments has risen from 33 in 1987 to almost 700 last year. From 1986 to 2014, the government recovered $44 billion under the False Claims Act. Now, more than 2/3 of that, or about 30-some plus billion, was recovered in cases filed by whistleblowers under the KTAM provisions of the False Claims Act. KTAM is a shortened version of a long Latin sentence that means he who files a claim on behalf of himself as well as the king. Now, these whistleblowers took significant risks to provide the information of fraud to the government, but fortunately, the False Claims Act rewards doing the right thing. And since 1986, whistleblowers have received over $4.7 billion under the False Claims Act. In recent years alone, whistleblowers helped recover approximately $3 billion and were rewarded $435 million. The federal government is moving beyond the False Claims Act recoveries and civil monetary penalties, and healthcare providers now face an era when healthcare noncompliance is increasingly being criminalized. The U.S. Department of Justice, the Criminal Division, announced recently that it is automatically now reviewing all new civil K-10 complaints for potential parallel criminal proceedings. The federal government's investigative methods, including the use of administrative HIPAA subpoenas, the product of which can be used either in a civil litigation or a criminal prosecution, has really weakened what has been a rather strong line of demarcation between civil and criminal cases. How does the False Claims Act work? Well, it provides a financial incentive for people with knowledge of false claims against the federal government to come forward. It does so by rewarding a successful relator, and this is the plaintiff in a False Claims Act case, with between 15 and 30% of any recovery from a defendant. Now, the relator files the False Claims Act suit. It's usually called a K-10 suit, on behalf of the United States government. It's filed under seal, which means it's not a public document, along with a disclosure statement providing evidence to the government. While it's under seal, the government investigates the allegations and decides whether or not to intervene, meaning they will take over the case. During this period of time, the defendant may not even know that the case has been filed. If the government intervenes, it becomes the primary prosecutor, although the relator still has some input. And the relator receives between 15 and 25% of any recovery. If the government decides not to intervene, the relator can still go forward, and if successful, would receive between 25 and 30% of any recovery. To prove a False Claims Act violation, you must show that the defendant was responsible for the false claim that was submitted to the federal government. Now, the relator, as I said, initially presents this evidence in a disclosure statement, and that's submitted to the government at the time the complaint is filed. The disclosure statement sets forth all the evidence that the relator possesses regarding the false claim, and it generally points the government to additional persons or documents that would substantiate the allegations. Now, the evidence provided needs to be as detailed as possible. It's not sufficient to base a complaint on rumors of wrongdoing. There should be specific allegations showing the time, the date, the place, and the content of any false claim. And it's also very helpful to have documentation supporting these allegations. It has to be shown by the civil standard, which means preponderance of the evidence, meaning it is more likely than not. It does not have to be shown by the criminal standard, which is beyond a reasonable doubt. And the relator does not have to show specific intent to defraud. The statute defines knowingly to include acting with deliberate ignorance or reckless disregard of the truth. Now, the 1986 amendments to the False Claims Act clarified and relaxed these burdens of proof, in part to prevent the ostrich or the head in the sand defense. For example, a physician signing off on a HCLA 1500 form would find it difficult to defend a False Claims Act violation by claiming that he knew nothing of the billing procedure and left it all to his staff. Now, anyone, underscore that, anyone with knowledge of the illegal conduct can bring a False Claims Act suit. Now, this is often a current or a former employee of the defendant. However, if the relator planned or initiated the False Claims Act violation, the reward to the relator may be reduced. And if the relator is criminally convicted for his or her role in the false claim, they must be dismissed from the suit. There are limits on bringing a False Claims Act suit. You must bring the case within 6 years of the date of the false claim, or within 3 years after the government, after the government knows or should have known of the false claim, but in no event can you bring the case later than 10 years after the false claim. In addition, if the allegations in the suit were already publicly disclosed, the relator has to be the original source of the allegations who brought the information to the government before filing the action. Now, prior to Obamacare, one could not bring a False Claims Act suit where the allegations were already the subject of a civil suit or an administrative monetary penalty proceeding where the government was a party. However, under Obamacare, that criteria has changed. The public disclosure jurisdictional bar substantially changed. Now it allows KTAM suits, even where the allegations were publicly disclosed and the relator does not possess independent knowledge of the allegations. In addition, because the public disclosure bar is no longer a jurisdictional bar, a dismissal of a KTAM suit on the basis of public disclosure may be opposed by the U.S. Department of Justice. Public disclosure is now limited to federal proceedings, public news, and social media. State proceedings and private litigation are not now considered public disclosure. In addition, before Obamacare, the relator needed to have direct and independent knowledge of the allegations. Now the direct knowledge requirement has been eliminated. To qualify as an original source, the relator must voluntarily provide information on the claim or the transaction to the government before the public disclosure, or the information must be independent of and materially add to the publicly disclosed information. There's a suit very recently in the Southern District of Ohio in which that court dismissed the whistleblower action that was alleging unnecessary spinal surgeries. The court found that the False Claims Act public disclosure bar applied because the allegations had been publicly disclosed and the relators, who were patients who allegedly underwent spinal surgeries, failed to establish original source status. The court found that prior complaints filed by other relators alleging the same claims against the same defendants, as well as a local news report detailing various lawsuits against the physician, constituted public disclosures. The court noted that so long as the government was on notice of the physician's alleged fraud with regard to the surgeries, it was on notice that the fraud could extend to the billing procedures used for those surgeries. And according to the court, merely being a patient in a medical procedure in which one thinks fraudulent activity occurs does not make one a relator with direct and independent knowledge. In this case, the alleged fraud involved the use of certain medical devices without the relator's informed consent. The relator who received the device was only made aware of it by counsel after the surgery took place. The court said that the information regarding the medical device at issue was acquired secondhand, and therefore there was public disclosure. This slide shows what the damages are under the False Claims Act. In addition to treble damages, costs, attorney's fees, and penalties, the Department of Justice recently increased the penalty range from a minimum of $5,500, from $5,000 to a minimum of $5,500, and a maximum from $10,000 to a maximum of $11,000 per false claim. Now, these are civil penalties. If a criminal charge is brought, the defendant also faces jail time. As this slide indicates, a violation of the anti-kickback statute or START can form the basis of a False Claims Act action. To understand how this works, let's review the anti-kickback statute so you can understand just what an anti-kickback violation is. We'll start with a review of what the statute is and how it can easily be violated. The anti-kickback statute is a particular section of the Social Security Act, but it's usually referred to as the anti-kickback statute. And it prohibits the offer or the payment, as well as the solicitation or receipt of any remuneration. Now, this includes any kickbacks, bribes, or rebates that are made in exchange for referrals. And the prohibited activity is a two-way street, and both the payer and the receiver are equally culpable. But what constitutes remuneration is a real gray area. Now, while the statute provides that remuneration includes any kickback, bribe, or rebate, it does not define these terms. Further, there's a prohibition against remuneration directly or indirectly, overtly or covertly, or in cash or in kind. Now, clearly, cash payments in exchange for referrals violate the statute. What's less clear, however, is what constitutes indirect payments. The intent of the anti-kickback law is to eliminate the payment for referrals of Medicare or Medicaid patients or business that is paid for by those programs. And any payment, including profit distributions, made to a physician or other healthcare provider by an activity to which that provider makes referrals of patients or goods or services is suspect. And while the statute is primarily aimed at prohibiting payment to physicians for referrals, it's not limited to that. And hospitals, long-term care facilities, and suppliers are not exempt from the statute. Now, there are 4 specific exceptions to the broad sweep of the general prohibition against remuneration. Number 1, a discount or price reduction to the provider that is properly disclosed and appropriately reflected in cost claims or charges made by the provider. 2, payments by an employer to a bona fide employee, and underscore bona fide, for employment in the provision of covered items or services. And we'll talk a little bit more about what constitutes a bona fide employee a little later in the presentation. Group purchase arrangements, but they have to be established by written contract with full disclosure, and the so-called safe harbors. Now, because the anti-kickback statute is extremely broad in its language, its scope is established by judicial interpretation. To date, the courts have interpreted the statute in a very expansive manner. Basically, if remuneration flows from one party to another, and if referrals or if the opportunity to provide goods and services flows back, the potential for criminal prosecution exists. And this is true regardless of the presence of good business reasons for the venture. Thus, even in the case of what those unfamiliar with the statute might consider normal business arrangements, the shadow of criminal sanction remains. Now, the leading case applying the anti-kickback statute is United States v. Gruber. This dealt with payments between a medical diagnostic company that provided Holter monitor services and physicians. The company billed Medicare for the monitoring services that it performed, and it forwarded 40% of those payments to the referring physician. Dr. Gruber at trial asserted that these payments to the referring physician were interpretation fees, and he was paying for the initial consultation and for explaining the test results to the patients. He argued that compensation for services actually performed did not violate the anti-kickback statute, unless there was a showing that the only purpose of the fee was to improperly induce future services. The court did not agree and established the one-purpose rule, which says if one purpose of the payment is to induce future referrals, the Medicare statute has been violated. Now, under this broad reading of the statute, any payments from a provider to a referral source could violate federal law. even if the payments were primarily intended to compensate the referral source for goods and services actually provided. Now, this broad interpretation was adopted in the Katz and the Bay State cases. Katz involved an agreement between a community medical clinic and a diagnostic laboratory to share Medicare payments received for laboratory services provided to patients who were referred to the clinic, referred by the clinic to the laboratory. The court cited Grieber. It said that the anti-kickback statute was violated if one of the purposes of the payment was to induce future referrals, even for professional services. The court said conviction is proper unless the payments involved were wholly and not incidentally involved and attributable to the delivery of goods and services. Now, in Bay State, we had the executive of a city-owned hospital who was charged with receiving illegal remuneration in the form of 2 automobiles and cash that he was paid for services rendered as a consultant to an ambulance company. The government contended he received the cars and the money to influence the hospital to award a contract to the ambulance company. The defendants at trial contended that the government had to show that the payments were not as compensation for services performed or were of substantially more value than the services performed. Interestingly, the court found the defendants guilty. The court said the gravamen of Medicare fraud is inducement, and giving a person the opportunity to earn money may well be an inducement to that person to channel potential Medicare patients' payments toward a particular recipient. The court said the statute is aimed at the inducement factor, and the text refers to any remuneration, and that includes not only sums for which no actual service was performed, but also those amounts for which some professional time was expended. In Bay State, the court adopted the more expansive reading of the statute in Grieber, stating that the issue of the sole versus primary reason for the payments is irrelevant, since any payment of inducement is illegal. Stark. Let's look at Stark for a minute. Now, Stark is a common industry name utilized in referring to the federal prohibition against physician self-referrals of Medicare patients. As I stated before, it's named for its chief congressional sponsor, Representative Pete Stark of California. The Stark Law addresses the inherent conflicts of interest that exist when a physician stands to gain financially from making patient care referrals. It was enacted in 2 distinct parts and has been the subject of numerous implementing regulations. It broadly prohibits physicians from making referrals to an entity for the furnishing of designated health services, and we'll talk about those in a minute, payable by Medicare. If the physician or if an immediate family member of the physician has a financial interest in the entity. Now, the prohibition contained in START applies only to the referral of patients for statutorily defined designated health services. Currently, I thought I had a slide on there. We go. Currently, designated health services are defined as, I have some of them up there on the stage: clinical laboratory services, physical therapy, radiology, radiation therapy, durable medical equipment, parental and enteral nutrients, equipment, supplies, prosthetics, home health services, outpatient prescription drugs, and inpatient and outpatient hospital services. One interesting thing about START is that you do not have to intend to violate the statute. There's no good faith or actual knowledge standard. You violate the statute, you're guilty, period. Now, the penalty for violation is denial of payment, except in 3 situations: where a person knows or should know that the improper claim was made, or where the refund has not been made, and there's a penalty of $15,000 for each prohibited service provided. Second, where a person knows or should know that the purpose of the arrangement is to circumvent the START law. And this includes penalties of up to $100,000 for each scheme. One of the schemes that came up very early, one of the circumvention schemes that came up very early, was the situation where I own a clinical lab and you own a clinical lab. Well, obviously, I can't refer to my clinical lab, but I can refer to yours, and you can't refer to your clinical lab, but you can refer to mine. So therefore, let's enter into an arrangement whereby I'll refer all my patients to you, and you refer all your patients to me. That doesn't work. That's called a circumvention scheme. And the third is for false reporting under START. And this includes a penalty of up to $10,000 per day. The statute is primary, enforcement primarily occurs through voluntary disclosures and private whistleblower actions. Defendants, quite frankly, are at the mercy of judges who do not understand the complexities of this statute. And one court noted that the law is so complex that it requires a Homerific odyssey to understand it. Now, this is a list of the most notable of the START exceptions. There are actually 32. And it's beyond the scope of this presentation to address each of them individually. Next, I want to look at compliance plans. This slide shows the issue that a good compliance plan should address. Let me address each of these individually. Introduction. This should say that the organization is committed to establishing and maintaining an effective compliance program. And this should be in accordance with the Office of the Inspector General's guidance. Now, the Office of the Inspector General, the Department of Health and Human Services, puts out lots of guidance information. So It's not difficult to understand what the OIG's guidance is. And the purpose should be to identify and prevent violations of law and policy. There should be a statement on policy and ethical practices. And this should state the organization's policy of maintaining the highest level of professional and ethical standards in the conduct of its business. It should specify that each and every employee, including management employees, is obligated to conduct themselves in a manner to ensure the maintenance of these standards. Written standards and procedures. The plan should state that the organization has created numerous compliance policies and procedures that enforce its commitment to comply with all federal and state law and regulations. It should also state that these compliance standards apply equally to all employees, regardless of tenure or rank within the organization. There should be a compliance coordinator that is identified in the plan. And the plan should identify who the compliance coordinator is and spell out this individual's responsibilities. This individual's duties should include, but not be limited to, education and training programs for employees, responding to inquiries from any employee regarding inappropriate billing, documentation, coding, or business practices. Excuse me. Should work with the Chief Executive Officer and should handle inquiries by employees regarding any aspect of compliance. Responsible for investigating any information or allegation concerning possible unethical or improper business practices, and recommending corrective action where necessary. Responsible for planning and overseeing regular periodic audits of the organization's operations. Responsible for developing policies and programs that encourage managers and employees to report suspected fraud. Responsible for preparing an annual report to the Chief Executive Officer. And finally, for encouraging employees to step forward and report any and all incidences of misbehavior. There should be a mechanism for voicing concerns. One function of the compliance program is to proactively identify issues and prevent compliance problems from developing. The plan should include a statement that managers, supervisors, and employees must not engage in retaliation or retribution or any form of harassment directed against an employee who has reported or is considering reporting a compliance concern. There should be a provision for education and training. This is an essential component of an effective compliance program. And the amount of training provided to employees will be directly related to how much their job requires them to be involved with the provision of services or in the coding or the billing of services. All employees should receive mandatory compliance training as part of their new employee orientation. Auditing and monitoring. This is an essential part of any effective compliance program, and it should be conducted under the direction of the corporate compliance coordinator. Response and prevention. The plan should provide that the compliance coordinator will promptly respond to any and all reports of noncompliance, and it should specify that records of such investigations will contain documentation of the alleged violation, a description of the investigative process, copies of interview notes and key documents, and the results of the investigation. Finally, enforcement and discipline. The plan should provide that the organization's code of conduct applies to all employees at any level and will be enforced regardless of an employee's position, rank, or tenure. Make it a living document. Don't put it on the shelf to gather dust. It's also important to get top management support and participation. Let's take a look at some case studies that involve both Stark and the anti-kickback statute. The Toomey healthcare system. Initially, a jury returned a verdict that Toomey had violated Stark, but not the False Claims Act. The trial judge, granted a new trial on the issue of the False Claims Act violation and found that the Stark law had been violated, as found by the jury, and ruled for the government on the issues of payment by mistake and unjust enrichment. Toomey appealed to the Fourth Circuit, which reversed and ordered a new trial. The Fourth Circuit reviewed the Stark law and found that unless there's an exception, if there is a financial relationship between the physicians and the designated health services entity, if the entity knowingly submits a claim in violation of Stark, the False Claims Act is violated. The Fourth Circuit indicated that anticipating referrals in computing physician compensation violates the volume or value standard of Stark. After remand, a second jury found that both Stark and the False Claims Act had been violated. And the judge imposed the statutory minimum penalty of $5,500 per claim and combined it with treble damages and fines and ruled that Toomey owed a total of more than $237.5 million for its billing practices in violation of Stark. Now, the government settled with Toomey for $72.4 million. Interestingly, the $237.5 million was more than the total gross revenue that the system produced. Now, this originated with a whistleblower lawsuit, and it was filed by a physician. And the United States government intervened in the lawsuit. And the government alleged that Toomey had violated Stark law when it entered into improper financial arrangements with 19 specialist physicians to perform outpatient services. More specifically, the government claimed that Toomey entered into part-time employment contracts with physicians in reaction to a freestanding ambulatory surgery center that the hospital determined would compete against it and lead to a decline in revenues. The government alleged a number of issues with the agreements, including that the physicians were paid in excess of fair market value as a result of fluctuating base salaries, productivity bonuses, and incentive bonuses that paid the physicians on average 31% more than their total net collections. The government argued that these payments varied with and took into account the volume or value of the physician's referrals. The jury agreed, finding that the Stark Law violations resulted in the submission of false claims to Medicare. It's important to note that healthcare executives are not always exempt from these sanctions. And in this case, the former CEO of Toomey Healthcare will personally pay $1 million to resolve his involvement in entering the physician compensation arrangements. He will also be excluded for 4 years from participating in any federal programs. Now, this means he can't work for anyone who accepts Medicare or Medicaid. The second opinion is Barassi. And in its opinion, the Seventh Circuit joined the Third, Fifth, Ninth, and 10th Circuits in adopting the one-purpose test first articulated in United States v. Gruber. Remember that case. By holding that if a payment is made, at least in part, to compensate past referrals or induce future referrals, the payment violates the anti-kickback statute. The court affirmed the lower court's loss calculation, finding that Barassi failed to produce evidence sufficient to rebut the government's loss calculations. Now, the relevant factual background in this case is that Barassi owned a group practice. It was located in Illinois, and it worked primarily with nursing homes and hospitals. The government alleged that at some point, Barassi and the chief executive officer of the hospital and the director of operations at the nearby inpatient psychiatric hospital conspired to pay kickbacks to Barassi and his group practice in exchange for increased Medicare referrals to the psychiatric hospital. At trial, Barassi and the chief executive officer argued that Barassi's group and the hospital entered into a variety of employment arrangements that justified the remuneration passing between them. The director of operations at Rock Creek pled guilty to all counts before trial and appeared as a witness with unfavorable testimony against Barassi. Specifically, Barassi contended that Rock Creek hired him and certain other physicians from his group to perform administrative services at the hospital. And therefore, all remuneration received of them was lawfully paid under the employment exception in the anti-kickback statute. The hospital designated Barassi as the service medical director and purportedly expected him to be on call at all times. However, the testimony at trial showed that the group's physicians were given false titles, fake job descriptions, and even were asked to submit false timesheets. And further testimony by the chief executive officer revealed that neither Barassi nor any other group practice physician employed by Rock Creek was expected to perform any of the administrative duties in their job descriptions. Although the parties agreed before trial that Barassi and the other physicians occasionally attended various committee meetings, each side pointed to the evidence of substantiating their respective trial theories. The government argued that Barassi attended only a very small percentage of these meetings, which supported its theory that the salary from Rock Creek was not justified. Barassi pointed to the reports in the meeting minutes of proof he earned his salary by providing actual medical services to the hospital. In addition, Rock Creek also paid the salary of the group practice's secretary and made lease payments to the group for an office in their building. Christ Hospital. This involves a major tertiary facility here in Cincinnati, and its then parent system, the Health Alliance of Greater Cincinnati. Together, these two defendants agreed to pay $1.8 million and enter into a corporate integrity agreement with the OIG to settle the accusations that the two entities violated the Anti-Kickback Statute and the False Claims Act. They were accused of illegally paying physicians in exchange for referring cardiac patients to the hospital. Well, the OIG notified Christ that it was considering excluding Christ based on the evidence that it improperly rewarded cardiologists for referring patients to Christ in violation of the Anti-Kickback Statute. The government alleged that the Christ Hospital, which is a 555-bed acute care hospital located here in Cincinnati, limited the opportunity to work in its heart station, which is an outpatient cardiology testing unit that provides non-invasive heart procedures, to those cardiologists who referred cardiac business to the hospital. The government further alleged that the cardiologists whose referrals contributed at least 2% of the hospital's yearly gross revenues were rewarded with a corresponding percentage of time at the heart station, where they had the opportunity to generate additional income by billing for the patients they treated in the unit and for any follow-up procedures that these patients required. The government said that the hospital's use of the heart station panel time to induce lucrative cardiac referrals violated the Anti-Kickback Statute. The government also alleged that the claims Christ Hospital submitted to Medicare and Medicaid as a result of this illegal kickback scheme constituted a violation of the False Claims Act. Now, the allegations resolved by the settlement were initiated by a whistleblower lawsuit filed under the K-10 provisions of the False Claims Act. The whistleblower in the suit was a cardiologist who formerly worked at Christ Hospital, and he received $23.5 million for the settlement. Another case, which I don't have up here, but it would involve the former CEO of a pharmaceutical marketing firm, was ordered to pay $1.5 million in restitution after pleading guilty to criminal tax evasion and tax charges. All right, let's take a look at marketing. What you can and you cannot do. What you can do is you can market your services. What you cannot do is pay for referrals. And if that marketing you're doing constitutes payment for referrals, you're in violation of the anti-kickback statute. The OIG puts out a lot of advisory opinions. And as this slide says, this is a legal opinion issued by the OIG to requesting parties about the application of the fraud and abuse authorities to the parties' existing or proposed business arrangement. An advisory opinion is legally binding on the Department of Health and Human Services, and it's legally binding on the requesting party or parties. Interestingly, it's not binding on any other government department or agency, and a party that receives a favorable advisory opinion is protected from the OIG's administrative sanctions so long as the arrangement at issue is conducted in accordance with the facts submitted to the OIG. A caveat, though, is that no person or entity can rely on an advisory opinion issued to someone else. Here are some of the more pertinent advisory opinions. Let me go through them one by one. Grocery store gift cards. This involved a health center's proposal to offer grocery store gift cards to certain patients in capitated management care plans as an incentive to receive health screenings or other clinical services. The health center would send letters to the enrollees of the capitated Medicaid managed care plans. The letters would be sent to all eligible enrollees, regardless of their health status. And the letter would offer eligible recipients with the opportunity to earn an incentive gift card redeemable for $20 in groceries. The OIG found that the arrangement would clearly constitute remuneration to federal health care program beneficiaries and would be of more than nominal value. However, the OIG said it would not be likely to influence beneficiaries to select the health center as their provider because of the affirmative election process to obtain assignment to a different federal health care program, and the relative modest value of the gift cards and the lack of advertising regarding the program. So, a technical violation, but they would not enforce it. Part-time physicians performing services as bona fide employees. The OIG found that the physician services the physician employees were to be employed to perform professional services, and the compensation they receive is for professional services they actually perform. And since the physicians are bona fide employees, their wages do not constitute prohibited remuneration under the anti-kickback statute. Consignment closets on site at certain hospitals. In this case, we had suppliers of DME that wanted to place inventory in consignment closets on site at certain hospitals, and then they would have licensed personnel on call or on site at the hospitals to train and educate patients who had been prescribed respiratory equipment and who had selected one of the companies as their supplier on discharge to their homes. The hospitals would provide the licensed personnel with a desk and a phone connected to the hospital's internal telephone system to facilitate the coordination of the services with the patient's treating physician, other clinicians, and the hospital's discharge staff. The hospital will not charge the suppliers for the use of the desk or the telephone. The OIG said that the proposed arrangement would not generate prohibited remuneration under the anti-kickback statute because no remuneration will flow from the suppliers to their potential referral source, the hospital and its staff. Under the arrangement, the referrals and all remuneration, the use of the closet, the desk, and the telephone would flow the same way from the hospital to the suppliers. Providing pagers to homebound patients. In this case, the requester proposed to provide free medical alert pagers and pager monitoring service to homebound patients. The OIG found that this would facilitate a rapid response to those who have fallen or injured or otherwise needed emergency assistance, and therefore it would prevent the need for more expensive care and services. And by ensuring prompt emergency assistance and potentially averting the need for more expensive care and services, the provision of the benefit is reasonably related to the delivery of home health services and to the fostering of efficiency and quality of care. Therefore, the arrangement would not violate the anti-kickback statute. Discounted ambulance services to nursing homes. Here, an ambulance company proposed to discount services to nursing homes. The OIG said flat out this arrangement would violate the anti-kickback statute. Sales commission to an independent manufacturer's rep. A sales agent was going to negotiate contracts on behalf of a manufacturer with healthcare systems in return for a commission of a percentage of the invoiced amounts. The OIG found that although technically a violation of the anti-kickback statute, they would not impose a penalty since the compensation was at fair market value. Percentage compensation. There are actually two advisory opinions here. In the first, a manufacturer of orthopedic products directly sells orthopedic products to orthopedic physicians and to other customers. Typically, the physicians purchase a supply of the orthopedic products for their offices sufficient to meet the anticipated needs of their patients. The physicians submit claims to third-party payers, including Medicare and Medicaid. Company B was a corporation engaged in the business of providing marketing, consulting, and medical billing in connection with home medical equipment. Now, the arrangement involved that the manufacturer entered into an arrangement with a marketing company for certain distribution, marketing, and billing services. And under this arrangement, the manufacturer would consign false goods and products to the marketing company, which in turn would consign them to physicians. The manufacturing company's personnel would provide the marketing company with initial introductions to current customer accounts, and the marketing company would assume responsibility for marketing to and servicing those accounts, as well as developing new ones. And under the arrangement, the marketing company would bill and accept assignment under its own provider numbers. And on a regular basis, it would forward reimbursements to the manufacturer, less the marketing company's fee, which would range from 20 to 25% of collected revenues. The marketing company would contact the payors and bill for the manufacturer's products according to a fee schedule devised by the marketing company. And this price list reflects the Medicare fee schedule ceiling for each item. In nearly all cases, the price listed exceeds the price at which the manufacturer currently sells the identical product to a purchaser. And in many cases, the price exceeds the manufacturer's price list by 4 or 5 times, and in one case by over 13 times. The marketing company's price to private paying companies is lower than the Medicare price in almost all cases. The contract also provides that the marketing company will provide consulting services to train manufacturer employees about sales and reimbursement issues at $1,000 per day plus travel expenses for those services. The OIG found that percentage compensation arrangements are particularly abusive because they provide financial incentives that may encourage overutilizations of items and services and may increase program costs. The OIG said the arrangement does not qualify for safe harbor protection under the Personal Services and Management Contract Safe Harbor, since the majority of the compensation is based on a percentage of reimbursements, and thus the amount of compensation to be paid to the marketing company under the contract is not fixed in advance and is determined in a manner that takes into account the value of the volume of business generated between the parties. In the other percentage compensation advisory opinion involved a physician corporation entering into arrangement with a private management company to operate a family practice. The physician corporation would provide the physician services. And in addition to providing space and equipment, the practice management company would be providing operating services, including accounting, billing, and purchasing, providing management and marketing services for the clinic, forming provider networks in which the physician corporation would agree to refer its patients to other providers in such networks. The physician corporation would compensate the management company based on a blend of various payments, including a percentage of physician corporation's monthly net revenues. The OIG said the arrangement is problematic. The compensation that the management company receives for its management services is a percentage of the physician corporation's net revenue, including revenue from business derived from managed care contracts arranged by the management company. The OIG said that such activities will potentially implicate the anti-kickback statute because the compensation would be in part for marketing services. And where such compensation is based on a percentage, there is at least a potential technical violation of the anti-kickback statute. Aggressive marketing by DME suppliers. The OIG said we have long been concerned about aggressive marketing by DME suppliers, including those marketing activities that involve direct contact with beneficiaries. Examples of what the OIG considers extremely coercive, particularly when such activities are targeted at senior citizens, Medicaid beneficiaries, and other particularly vulnerable patients, are door-to-door marketing, telephone solicitations, direct mailings, and in-person sales pitches or informational sessions. These activities are highly susceptible to fraud and abuse, the OIG said, and they can lead to overutilization, increased costs to the Medicare and Medicaid programs and the beneficiaries, and inappropriate medical choices, as well as adverse effects on the quality of care that the patients receive. Arrangements that offer DME suppliers opportunities for access to hospital staff and patients are particularly susceptible to problematic marketing schemes, so said the OIG. The OIG also puts out other compliance guidance, which includes special fraud alerts, advisory bulletins, and other program guidance. Let's take a look at some of these. The first one involves physician-owned entities. And the OIG defines these entities as any physician-owned entity that derives revenue from selling or arranging for the sale of implantable medical devices. This includes physician-owned entities that purport to design and manufacture, typically under contractual arrangements, their own medical devices and instrumentation. These include implantable devices that are surgeon implants. But the OIG said that the same principles would apply when evaluating arrangements involving other types of physician-owned entities. The OIG stated categorically, "We believe that physician-owned entities are inherently suspect under the anti-kickback statute." Marketing, telemarketing by DME suppliers. DME suppliers are prohibited from making unsolicited telephone calls to Medicare beneficiaries, except in 3 specific situations: where the beneficiary has given written permission to the supplier to make the contact, where the contact is regarding a covered item that the supplier has already furnished, and where the supplier has furnished, or when the supplier has furnished at least one covered item to the beneficiary during the preceding 15 months. Now, the Social Security Act specifically prohibits a supplier that knowingly submits a claim generated pursuant to a prohibited telephone solicitation. Accordingly, such claims for claimant are false, and violators are potentially subject to criminal, civil, and administrative penalties, including exclusion from federal health care programs. Now, some DME suppliers continue to use independent marketing firms to make the unsolicited calls. And the OIG simply said suppliers cannot do indirectly what they are prohibited from doing directly. Rental of space in physician offices. There's a number of suppliers that provide healthcare items or services. The physicians rent space in the offices of those physicians. Now, the OIG is concerned that such arrangements that the rental payments may be disguised as kickbacks to the physician landlords to induce referrals. The OIG said it had received numerous credible reports that in many cases, suppliers whose businesses depend on physician referrals offer and pay, quote, rents, unquote, that are either unnecessary or in excess of the fair market value of the space or access to the physician's potential referrals. Sometimes, said the OIG, the space is little more than a broom closet. The OIG also puts out advisory bulletins. And the first of these that we'll talk about is contractual joint ventures. This is where a hospital expands into a related service line by contracting with an existing provider of that service. The OIG says there are several problems with this type of venture. First, it depends on referrals from the hospital's existing business. Next, the hospital neither operates nor commits substantial financial, capital, or human resources to the venture. And the contractor is an established provider of the same service as the hospital's new line of business and could go into that business itself without the help of the hospital. And the hospital and the contractor share in the economic benefit. And the payments to the manager and supplier typically vary with the value or the volume of the business. Offering gifts to beneficiaries. Offering gifts to beneficiaries to influence their choice of Medicare or Medicaid provider is suspect. There are some exceptions. Inexpensive gifts, waiver of cost-sharing amounts based on financial need, properly disclosed co-payment differentials in health plans, incentives to promote the delivery of certain preventive care services, any practice permitted under the federal anti-kickback statute pursuant to the safe harbors, or waivers of hospital outpatient co-payments in excess of the minimum co-payment amounts. Find the advisory bulletin on practices of business consultants. The OIG raises several questionable practices. Illegal or misleading representations. OIG said the consultants may make illegal or misleading representations about their relationship with the Medicare program, CMS, or the OIG. They may make explicitly or implicitly promises and guarantees of specific results that are either unreasonable or improbable. And a lot of times consultants will encourage abusive practices. And discourage compliance efforts. They even make blanket statements that a client should not undertake certain compliance efforts, such as retrospective billing views or cooperate with payer audits. Finally, we have program guidance. And this guidance concerns providing free fax machines and computers used to receive lab results, etc. The OIG said so long as the good or service can only be used for the express purpose, it's not a problem. However, if it can be used for other purposes, for instance, the computer has a definite value to the physician, and depending on the circumstances, may well constitute an illegal inducement. And where the intent of the parties is to induce or encourage the referral of federal program business, the statute would be violated by such a practice. I've got about 7 minutes left. I'd like to use that time to briefly look at some recent case law that provides some guidance. United States v. Robinson. In this case, Robinson owned and operated a company that provided DME to Medicare beneficiaries. And he paid kickbacks to 2 individuals in exchange for Medicare beneficiary information. A jury convicted him of conspiracy to violate the anti-kickback statute and of paying kickbacks in violation of the anti-kickback statute. On appeal, he argued that his conduct was exempted under the statutory employment safe harbor. Remember, that protects bona fide employee relationships. The appeals court rejected the defense that the two individuals were bona fide employees. The court said that the safe harbor only applies to any amount paid by an employer to an employee who has a bona fide employment relationship with such employee. And the evidence indicated that both individuals were paid either a fee or a commission for each referral of a Medicare beneficiary. Therefore, the compensation was not fixed in advance and varied with the volume or value of the business. Medical development network involved a contract between a DME company and a marketing company, and the DME company paid the marketing company a percentage of business it developed for the DME company through its marketing program. And the court said that this approach violated the anti-kickback statute. The Walgreens case is kind of interesting. This case settled for almost $8 million, and the scheme involved offering gift cards and discounts to transfer business to the pharmacy. The program was not intended to apply to Medicare and Medicaid patients. However, the ads were mailed to 6 million AARP members, and all patients who applied received the gifts or discounts. Zimmer. In this case, New Tech, a marketing company, arranged for the purchase of Zimmer ortho products. It was to receive a percentage of the arranged sales. The court held that the arrangement violated the anti-kickback statute. Miles. This is an interesting case. This is where a home health agency contracted with an ad firm to distribute advertisements to physicians. When the physician wanted to order home care, the ad firm was contacted, who in turn furnished the information to the home health agency. The ad firm was paid $300 for each patient that became a client of the home health agency. The court held that there was no violation of the anti-kickback statute because the ad firm was not the decision maker and had no influence over the decision. In contrast this with Robinson, which we discussed earlier, and Pollen. Pollen, a pacemaker monitoring service, made payments to a pacemaker sales representative based on the number of patients that he signed up with the service. But the salesman's responsibilities including selling pacemakers, attending implant procedures, and making sure that patients were monitored following implantation. When a physician decided to use an outside service, the salesman would contact the service provider and set up the monitoring for the patient. The salesman would make the decision as to which service provider to contact for the patient. And because the salesman was a relevant decision maker and his judgment was shown to have improperly influenced the payments he received from the monitoring service, the anti-kickback statute was violated. Shoemaker, this is also an interesting case. Here we have the CEO of a hospital in Batesville, Mississippi, the owner of a staffing company, and the board chairman of the hospital. The staffing company paid the board chairman $5 for every nursing hour that the staffing company billed the hospital in return for the board chairman's ensuring that the hospital used the staffing company for contract nurses. And about once a month, the company would push the board chairman to increase the nursing hours, and the board chairman would lobby the CEO accordingly. After the arrangement began, The board chairman signed a board authorization giving the CEO a $50,000 raise. The Fifth Circuit upheld the convictions for violation of the anti-kickback statute. The court said Chandler was an agent who was authorized to act on behalf of the hospital, not only in the general manager, but respect to the hospital's funds. The chairman's position as chairman of the hospital's board fell within the statutory definition of director or officer. In addition, he was at the top of the organization and had full authority over its funds. I'm going to skip Cobb and go directly to the conclusion. My conclusion is that getting paid is important. But the healthcare fraud and abuse laws are very complicated and complex. Nevertheless, you are responsible for compliance. So you should get good advice from someone who practices in this area and understands its idiosyncrasies. While they cannot be eliminated, the risk can be eliminated. And I recommend a good compliance program. I recommend you conduct internal audits. Review all contracts with physicians, particularly those in a position to refer. Develop a good training program. Make sure you understand and comply with the law. That comes under the heading of get good advice and follow it. And develop a culture of compliance. And above all, maintain quality of care. This is my disclaimer. I'm not intending to provide legal advice. You should get good legal advice from someone well-versed in healthcare fraud and abuse. I'll stop there and see if there are any questions.